Following the brutal slayings of the Martinez family at the Parnell Cattle and Horse Ranch by their relative Arturo Juarez Suarez, Yolanda Martinez, the only survivor, will have a winding road to cross to see justice done and the killer of her family brought to justice. We will discuss the issues of immigration, translators in court, and a 31-year-old treaty that the U.S. signed in this episode of California True Crime, Arturo Juarez Suarez and the Martinez Family Murders, Part 3. Welcome to another episode of California True Crime. As for the last couple of episodes, I'm Charles. I'm leading us through the story of these murders and rape. And this episode, we're going to really focus on the court phase and the trial of Arturo Juarez Suarez, who is charged with the killing of Jose, Jack, Ariel, and Juan Martinez, and the rape and beating of Yolanda Martinez. We left off as he had fled from Auburn to Southern California. He was tracked there by some quick thinking from a clerk at a local Long's drugstore and an FBI analyst. He was arrested and interrogated a few times, each time confessing to the crimes, or at least the murders. He would not admit to the rape, ever. He was arraigned and was awaiting trial, which is where we'll pick up the story today. Before we begin, is there anything that we'd like to discuss, or have you guys, at this point, we went through the initial crime, his flight from justice, and the tracking and arresting him, as well as his first entrance into court. Is there anything that you guys would like to share or speak on before we begin the next phase?
No, I've been looking forward to hearing more about Yolanda and her advocacy for herself and her family. I know you've talked to me a little bit about it, so I think it's a really important topic, and I'm glad we're going to get to that.
So much of this story, I mean, again, if you haven't listened to the other two parts of the story, please go back and download those and listen to those first before this one. But if you listened to California True Crime at all before this, you know that we always kind of talk about how some of these stories stay with us and over time. This is again another instance of one where Yolanda's story, I can't imagine going through what she went through, on top of which then being forced to relive it through the court case. And I think we will talk about it in this episode a lot that has to do with everything. Her testimony is not necessarily the linchpin in this case. They have a mountain of evidence that points to Suarez being the perpetrator of it. But it's through her testimony and through her advocacy and really through her presence in the court that she is a constant reminder of the chaos that's left in the wake after this crime. We're now into August of 1998. Yolanda Martinez is alone and having to face down the murderer of her family, not to mention the same man that beat and raped her in court. And she has no one to call on for support. This is due to the fact that the remainder of her family are living in Mexico. She's not working, as Jose and Juan were the ones that were supporting the family, and she had two small children at home. So she was their caretaker, she took care of the family, but without them, she has no means of supporting herself. She will be interviewed by the Sacramento Bee early on, stating, quote, "I'm very sad. I don't feel like going out, so I just stay home every day. Right now, I'd be happy if my sister could come be with me. That is all I really want. One relative by my side," unquote. A social worker by the name of Irma Mendez of the Galt Concilio said that Yolanda was not getting all the services that she might have been because there was not enough translators to help her out in these situations. So, I think at this point, I really want to highlight that the importance of making sure that the people that need the help can get the help. And right now, there is services available for her in Galt where she's living, but because they don't have enough trained translators to help, Yolanda can't get the services, because how do you give services to somebody? How do you give counseling to somebody that you can't speak to in their own language?
And she has to stay here, really. I mean, she could go, and I mean, in theory, if she had someone, she could go stay with family. But I mean, she's the key witness to this trial, so she has to stay in this area. I think that has to be really hard, especially by herself. And as we know, this could take a long time to go to trial. I mean, I don't know what happens here, but in other cases we've seen it could take years. So
and
she's
that's
kind of stuck.
That is the case in this one, this court case. And we will go. I will say this, unlike some of the other cases that I know I've researched on, we will go over every kind of step in the judicial process because of how winding this goes, and highlighting the fact that at every step Yolanda has to be there, and she can't. And the prosecutor will say she's our key witness. Again, they have a mountain of evidence pointing to this guy, but none of it will be as impactful as the victim saying, this man did it. And I think that will speak volumes for those people that are trying to help and find her help in other avenues and trying to support her. But the fact of the matter is, this is one woman who's absolutely alone here and has no support. You know, I again, like the social worker was saying, we want to help her. We don't have the means. So I think that's just kind of a small way for me of saying that I think it's often at times that we need to do a better job of helping those organizations that help victims after the fact. So the director of the INS office in San Francisco, which this office oversees this part of Northern California, the person's name is Lionel Nurse. And he connected the family and worked with Yolanda and Yolanda's family in Mexico in order to get the bodies of her family transported back to Mexico for the funeral. Yolanda's family had come to the United States, so he had gotten them a 15-day pass to come to the United States to pick her up, to take the bodies back to Mexico, where they would be buried, and then they'd return. So Nurse personally talks to the family about helping them with this trip and tells them that they are to call him when they're ready to return to the United States 4 days after the funeral. Now, that was because they were that he would organize it. He had everything kind of lined up. They were going to, and then they would call. He would organize the trip back, and then her sister and brother-in-law, Yolanda's sister and sister's husband, would then come back with her, and then they would be able to stay here for the length of the trial to support and care for Yolanda in any way that she needed. The issue happens in the meantime, while Yolanda Martinez and her family are transporting the bodies of her family for burial. Nurse is actually transferred to a new position within the INS. Now, this means that any deal that he had made with a family does not necessarily have to be followed by the new person that takes over his position. And that is exactly what's going to happen. No one told the family. So we have a new person come into Nurse position. He says, no, I'm not going to honor any of these deals. But nobody bothered to call Yolanda Martinez and her family in Mexico saying, by the way, you don't have set travel plans back to the United States. And the only way that they found out is when they got to the airport to come back to the United States, and they were stopped at the gate. Yolanda was let through because she has permission from the court to say, you need to come back in because you're a material witness, but your support structure, they don't have passes, so they have to stay here. So her family's left literally at the gate holding airline tickets going, we'll come support you, and they're not allowed to. So Yolanda at this point has to return to California on her own again, after just burying her husband, her two children, and her brother-in-law, and then leaving her sister, her only support structure, back in Mexico.
So when you say INS, you're talking about, currently now it's called the Immigrations and Customs Enforcement, or ICE. In the 90s, it was called Immigration and Naturalization Service. So you're talking about just kind of the overall federal immigration.
Right. It's the organization that deals with immigration, naturalization, and citizenship in the United States. Now, at this point, when she comes back into the United States, a spokesman for, and again, we'll continue to use the terms that were used in 1998, but it's the Naturalization Service that's located in San Francisco. And again, San Francisco oversees all of Northern California. And they will say, that the request request to travel is only given in an emergency basis. So basically, and I found this interesting, is that everyone is shocked by this. The Placer County Court is shocked by this. The police are shocked by this. When Yolanda comes back, everyone was like, well, wait a minute, your family's supposed to be with you, and they're not. Newspaper reporters contact the Naturalization Service, and their spokesman says, no. That is only given, permission to travel like this is only given in an emergency basis. Now, the official at this time who replaces Nurse is a person by the name of Thomas Schlichting. Sorry, I don't pronounce that quite correctly, but he is the current director of INS in San Francisco who takes over for Nurse. And he says that the family could still come through, but they have to go through regular immigration channels. And this means that they would have to do one of two things. Either A, request a visitor's visa from the U.S. Embassy in Mexico City, or two, if it's turned down, that's the first thing they do. They go in, request a visa. If it's turned down, then they could apply to INS directly at the INS office in Mexico City, and they'd have to do that under the idea of humanitarian parole. So I can go to the consulate and say, I want to travel to the United States, please. And they would say, if they said no, then I can go directly to the immigration office that's also in Mexico City and say, I need to get to the United States because of humanitarian needs. So remember, her Nurse already made this deal with him and said, yeah, INS is 100% okay with you doing this. But because that's on his word, he gets removed. And this new guy comes in and says, no, just kidding. That's not the rules. The rules is you have to do it this way. Now, at this point, I think this is I am constantly astounded by, and I'm happy to see how people support one another. And sometimes when we do these stories, and this is another example, Michael Considine, who is actually a lawyer that donates his time to Yolanda and says, let me help you with this, who's representing her at no charge, states, quote, this lady's entire family was murdered. She's really fragile and has nobody here, no family support network to provide emotional support she needs, unquote. In fact, Senator Barbara Boxer and Dianne Feinstein would write letters to the embassy in Mexico to ask for the family to be allowed to come to the United States and explain that this was an extreme case and an emergency. Yolanda's family would eventually be allowed to return to support her, but it would take the influence of 2 California senators, as well as public outcry from the media, in order to get them in time for Yolanda's first court appearance. And I think, to me, this one really strikes me as the power that some individuals have with very little oversight sometimes, is that it's one person's word that could make or break this. And that, if you don't look at a case of a woman's entire family being massacred as an emergency, like, what is your definition of emergency then? It is in late August of 1998, the Maria del Carmen Olivares will receive a long-term visa to be here in the United States for the trial and to take care of her sister Yolanda. She comes with her husband to be here for Yolanda for the length of the trial. So eventually she gets up, but we're going on like almost a month and a half after this event. They're here, which is at least one battle that Yolanda has won in this whole thing. It would also be in late August of 1998, the public defender Tauman would ask Judge Cousins for a gag order in this case. Now, we've talked about this before. He would charge the DA with making extrajudicial statements to the media about the case that might taint the jury pool and interfere with his clients getting a fair trial. He will state, quote, coverage has been sensational and widespread. This can resonate with jurors who will be seated in this case, unquote.
So he's making the statement about the DA and not the newspapers or the news? That the DA is tainting the jury pool?
Yes. Okay. Yeah, this is specifically because of what the DA is saying. And we've talked about this from time to time, and and this is a big, like I said, this case is really well covered, specifically by the Auburn, Placer, and Sacramento newspapers, and they're at the court. In some cases, these reporters are in the court every single day. But specifically, this is going to unfold more as the case goes on. Now, the reason for his appeal for this gag order specifically is because of statements that DA Finocchio makes when asked about the arrest and the trial to come. And this is a quote from the DA. Quote, justice will demand we seek the death penalty in the case, unquote. So the defense attorney says, whoa, that's an inflammatory statement. He needs to be muzzled because because people are already going to think that this is going to be a sensational case, that it's going to taint the jury pool. Now, the second time that something is said is August 12th, and it was in the form of a press release distributed by the sheriff coroner's office that states the facts of the autopsies in regards to the 2 children being buried alive. Talman would go on to say, quote, "The DA in this case is not informing, he's selling. They are neither natural nor factual," unquote. Meaning that he's trying to get the court of public opinion to convict Suarez before they ever get to trial. So in essence, Talman is saying, I need a gag order because not only is he going out and saying that this is that justice demands the death penalty, but his office allowed the sheriff and the coroner's office, because in Placer it's one office, sheriff coroner, to release this report to the media that explained how the children died. He said, well, the people are already going to know how those kids died before they come to court. That's going to taint the jury pool because they're going to come into town. They're going to come into the jury box with preconceived notions about the person sitting in front of them.
The first quote that you gave didn't really seem pretty normal for these kinds of cases. And I would say that if it is getting a lot of media attention, gag orders seem to be pretty regular for the stuff we've covered. But, a month later, there's this press release from the coroner. It does seem kind of an odd thing to do.
Yeah, I'm with you. I think the first statement almost seems off the cuff. Like, I don't understand how that would change. It's a murder case involving 2 children. I would think, like, yeah, well, obviously it's going to be a death penalty case. I think the second one has a little bit easier time to argue that. Like, I could say I could make that argument more than I could the first statement. Now, the judge will say that the defense, Talman, was out of line attacking the prosecution and their statements. In fact, in court, Talman actually has to apologize to Finocchio, who acknowledges his apology with a slight nod of his head. In fact, the newspapers actually report it like that Talman actually apologizes in court in front of everyone, and the DA gives him the kind of like nod of his head, just saying, yeah, I understand. The judge will side with the prosecution in this case, but he will issue a gag order on all parties from talking about this case when it goes to the media or in the public. And this will start to change the coverage of the case. And I think this is interesting because of how the coverage changes then. This means that for the rest of the case, there will have to be someone in the courtroom for the entire time reporting on the facts in order to get those stories out to the public. This also means that you'll see a lot of these stories being repeated in the media sources that are not able to get a reporter in the courtroom. And I think that's why when we see coverage from like newspapers in LA and through lower Central California, they're all verbatim. It's taken directly from those reporters in Sacramento and Placer and Auburn because they have an easier time putting somebody in the court. I also think it's interesting because it stuck me, and I don't know how you guys feel about this, and I know we've talked about gag orders, but on one hand, I understand the need for them because you don't want a jury to be unduly biased. At the same time, it does hurt some of these cases being known beyond local, like getting the notoriety. I don't want to say notoriety is the right word. Getting the media coverage for some of these cases or these victims outside of that is because the news agencies don't know about what's going on.
I don't know. I think I understand what you're saying. I think just because in so many of the cases we've covered, them being overturned for whatever reason, for this reason or that reason, seems to do so much damage that even for the victims in this case, whatever they can do so that she doesn't have to go through a second trial. Obviously, it's death penalty case, so appeals and stuff, but if this is the way to make sure that doesn't happen, I'd be for it.
I understand what you're saying, Jessica. I think it's important for the surviving victim that there's no way that it could be painless, but as painless as possible to get everything correct where she can go on.
Now, by September, the defense will ask for more time. The court will push the date back to December 2nd for the preliminary hearing. So we're just starting with the preliminary hearing. We haven't he's already been arraigned, but because of these objections and the gag orders, they're pushing this date back further and further.
Hi, we're the Curiosity of a Child podcast.
I'm Anton, the son.
Age 10, and I'm the daddy.
Daddy. I'm the daddy. Aged a few multiples of 10.
And we're curious about, well...
everything.
The more you look at the world, the more you understand, and then the more you will see. We're a podcast about history, science, storytelling, and...
the curiosity of a child.
We like to dig into different topics, everything from the humble ox...
They've been really important for the development of mankind, and in that episode I had to learn about castration.
Sorry about that. To the most popular Christmas toys of yesteryear. We don't just talk, though. We like to experience. That might mean recording on location in a 5,000-year-old dolmen full of spiders and reportedly the entrance to the fairy realm.
Or simply tasting spices from across the world to uncover where they came from, how the trade affected people's lives, and how they were used.
So, please listen to the...
Curiosity of a Child
Dun dun.
podcast.
Galt is a town about an hour drive south of Auburn. At the time, especially in the 90s, it was a farming community. It still really is. It's also, I think, more and more a suburb of Sacramento and places like Elk Grove. At the time, around this time, it would have had about 19,000 people living there. So it's a pretty small community that they're living in. We know it because growing up, it had a huge flea market. At least that's how I know it. You would go to that. I don't know if you guys have any other information about Galt.
Yeah, I think Galt now is, like you said, it's not only a farming community, it is becoming a suburb from some larger areas. I know, having lived in Stockton and worked in Stockton for a while, I know a lot of friends and colleagues would live in Galt and commute to Stockton or use Galt as a way station on to, like Sacramento and stuff. It's a really nice community. And the reason why we bring it up now is because, remember, the Martinez family is from Galt. This is where they live. And the children went to a Delta Community Head Start program in Galt. And I want to spend a little time talking about, and we'll kind of go back and forth to this, but this community, again, predominantly farming community at this time. It is 19,000, so it's a little bigger than Auburn, but Galt has a really small town feel. And for example, when news of the children's death happens, the counselors are called in, and where the kids attended school, to help the community understand and heal from this. Everyone in the community commented on how nice the family was and want to support. They're actually going to work through the course of the trial to raise money to help Yolanda and her expenses while she's waiting to testify. Because remember, she's not working. On top of which, her sister and husband are here, and so really they're kind of living off the kindness of strangers, to borrow another line. And the community of Galt, there will hold different fundraisers throughout this entire process to come together. They advertise in larger newspapers. They sell dinners. They help collect clothes and food and things like that. And so, again, I think I wanted to highlight that to show how powerful community support can be, and we've talked about it a lot while we've done this podcast, but when these crimes happen, it doesn't just happen to the victim, it happens to the community at large. And even the people in Galt will comment is that the Martinez had not been there very long, but it didn't matter because they were part of the community. Now, so even though the preliminary hearing is supposed to start soon, it doesn't actually get started until January 1999. So even though the court says, well, we're going to start it in December, it actually, when push gets to shove, gets pushed back till 1999. On the first day of the trial, on the preliminary hearing, the DA lays out their entire case that they have against Suarez. The mountains of evidence that they have collected and cataloged were put on display for the court and the public to see. But this would not be what people were talking about. What would be reported in the newspapers would be Yolanda's testimony on the stand. And this would become the powerful first shot of the case. On the first day of the hearing, Yolanda is called to testify and confront her attacker. This is it's a Placer County courthouse. It's not the biggest but you have a woman was brutally beaten and raped, whose 2 children were buried alive, whose husband and brother-in-law were shot execution style and buried in a shallow grave. And she's sitting in a courtroom confronting the person that did that, sitting not 15 feet away from her. This is one of, if not the first time she's been in the same room since the day of attack and the murders. She begins her testimony with, quote, "He ripped my clothes off," unquote. The rest becomes a torrent of screams and yells directed towards Suarez. From the accounts in the newspaper, she shuts the courtroom down. She begins by testifying about the events of the day that her family was murdered and continues through the rape. Her voice will gradually raise in volume until the time when she launches into a verbal assault on Suarez. She says that she hates him, that he hopes he dies and rots in hell, calls him the scum of the earth. The word that she repeatedly called, and we used this I think in the last episode, is disgraciado. This term translates loosely to, quote, "scum of the earth," unquote. I found it interesting that in one of the Auburn papers, though, a person will write into the opinion section and said technically the word has a different connotation, and that's the connotation that she thought Yolanda was using. And it means somebody who has been betrayed by somebody else, but more importantly used somebody who is removed from the grace of God. In this case, meaning that Suarez would have no chance of redemption or a place in the afterlife, and that he would be damned for eternity. While she is yelling at the defendant, no one in court moves to stop her or tell her to stop or to quiet down. In fact, the newspaper makes special mention that the fact that the sheriffs are there to act as bailiffs are so uncomfortable and are so unsure of what to do that everyone keeps looking at one another, but no one stops her. Not the judge, not the prosecutor, not the defense attorney. This goes true for the translator, who is having to repeat everything she says from Spanish to English. The translator is in tears. The newspaper will say, quote, "She lost it all on July 12th, 1998. What's justice to her? Justice will never bring her family back," unquote. The judge will call a recess until the next day to allow Yolanda to collect herself. The next day, the testimony would continue. She would complete it in court. She would describe the attack, having her children dragged from her, and being left in the trailer. She would describe the escape and the running to the Parnell family ranch home. At the end of the preliminary hearing, Judge Cousins will set a date of February 23rd, 1999 for the Superior Court arraignment on 4 counts of murder, 1 count of rape, and a special allegations for the use of a gun. By the time the arraignment happens, the DA actually has 20 different new counts and special allegations on the 5 different charges. They include 2 new counts with the rape charge, which included kidnapping for the purpose of rape. February 1999, Tauman entered a plea for Suarez of innocence on all charges, counts, and special allegations. Which brings us up to March. By March of 1999, the defense had brought up some issues with the original translator that were used during the arrest and the initial interviews of Suarez. Remember, we talked about that before with the issues of how those translations were done. It was found that she was not a licensed translator at all. The defense asked for the tapes of the initial interview as well as the preliminary hearings, especially that of Yolanda, to be just transcribed. They would then want a certified translator to go over the tapes and see if there were mistakes made and how badly those mistakes were. Tauman had said that he was not trying to make a roadblock, but he wanted to avoid one. He had previously positioned the court to drop some or all of the charges. And I think this lays out kind of the groundwork of Tauman's and why Tauman's, I would say, a good defense attorney is because he's finding these avenues that you can argue, and he's sticking to those. And he's saying that, oh, there's a translator. Well, let's see if that translator is not licensed. That could be an issue. And so he's delaying. It's like a delaying tactic over and over and over again.
So this is the translation from the Parnell's home.
No, this is actually the translation that was used
in court. Okay.
So what they're doing is, and again, at this point, we're all in the preliminary hearing so far. So we're using Placer County translators. So what Tauman is saying is, I want the tapes from the confession. You're right. I want the tapes from the initial Parnell, but I also want them from his first confession at Placer County. I want the tapes from Yolanda's amazing testimony at the preliminary hearing. I want them all to look at, and he found that this specific translator was not licensed by whichever organization controls translators, not controls, but like I get certified as an actual court translator. And he's saying that because of that, there could be mistakes made. So we need to delay until an actual certified translator will go over all of the documentation, all of the transcripts, all of the tapes, and see if there are mistakes made and how badly those mistakes were made.
That seems really interesting that they didn't know that the person was licensed.
Well, and I think I can understand it for initially for like, you know, I would say the initial interrogations, because right then you're interested in like, I need to find somebody that speaks Spanish. So I'll find somebody in the office and, that person who's always our go-to person for speaking Spanish or speaking any language, I think of that person as a translator rather than somebody who's actually a licensed translator. The trouble with a translator would be heard by the Superior Court in April of 1999. So remember, this is supposed to start in February. Because of this, we're already delayed 2 months. The judge will say at this time that the testimony could not be certified because the fact that the translator was not licensed and that the tapes of the recording were such a poor quality, which means that, again, 98 recording technology, even in a courtroom, a public courtroom, probably is not that great. And so the tapes they have are such poor quality that I can't have a new transcript from that. And the transcripts that were made were from an unlicensed translator. So Judge Cousins is saying, I'm not certifying this as accurate. I'm just saying that there might be a problem. And he's kind of passing that buck off to somebody else. Now, these tapes and transcripts were then given to Daniel M. Roberts. He is a certified interpreter. He reviews the tapes. Now, what he says is, quote, all the tapes were poor quality with extensive sections that are hard to understand, unquote. He will say that the interpreter did not follow accepted procedure, allowing an utterance to be completed before proceeding to translate it. And I think that was important to me because how many times I know in my professional life I've worked with translators in the past, and I've never really made the connection. Some of them will start translating before I finish saying what I'm saying, and vice versa. They're trying to summarize what the person is saying instead of translating directly what they're saying. I thought that was interesting. Roberts does not pass judgment on the tapes, though. He doesn't say that they're good or bad. He just says he prepares a report. Judge Cousins takes that report, and once he reviews it, he says he declines to dismiss the case on these grounds. So he says, Tauman, we're not dismissing the case. He does not certify the tapes and the transcripts record, though. He says, I can't certify them. I'm not going to certify them as official because of the mistakes that were made and what Roberts says in his reports. But he does say that those mistakes do not alter the tenor or tone of the testimony. However, he doesn't make a final judgment on the case. He says the issue is going to go before another judge, James L. Reuter, who's going to hear the motion in April 20th of that same month. This judge refuses to dismiss the entire case as well, based on this. He says that the non-certification of the record and the faulty performance of the translator is not enough to dismiss the case.
And this is because during the preliminary hearing, they brought forth all that other evidence.
100%. Right? So they say, A, you have a mountain of evidence pointing to this guy. B, you have multiple confessions that are not done by this one translator. And C, you have Yolanda repeatedly saying the same thing. Whether the exact translation in the court of her outburst, and I hate to use that term, it's not an outburst, her righteous indignation, none of that matters. This case is going to go forward. Tauman will tell the court that he will seek an appeal to the decision. This decision will stand, however, and on May 4th, 1999, a trial date of October 4th, 1999 will be set. So again, Talman is saying, and I think this is what a defense attorney has to do. And I think, again, we know this, we know he did it, we know he's guilty. So it's hard sometimes, but I think this is the purpose of the justice system is the defense attorney has to say, this is where I can pick apart the case. I'm gonna lay this down and see what happens. And he gets his client more time. And now that, on the other side of that allows the defense more time to put their case together.
To be fair, it does seem like a pretty big mistake on the part of whoever's job that is to decide the prosecution or the court itself.
100%. And that's no shade thrown on Placer County DA's office or the police department. I think it's just one of those cases and I think you mentioned it just a minute ago, Shauna, well, why wouldn't they? Depending on how big the office is and how many people or what access do you have translation services and, do they have their own office in-house translator or do you have to go somewhere else?
Well, it's an interesting question about who even checks that. You'd think kind of the court might check that,
right.
Make sure that everybody has the
right certifications and qualifications.
Which is interesting.
In September of 1999, the defense will attack the search and seizure that was done at the time of the initial investigation. So remember, in the first episode, I did belabor the fact that they actually had a warrant to go into his trailer. The main reason is that the defense will say that the authorities did not have a warrant on that first day when they went into the ranch and began searching. So what he's specifically calling out is the night that the murder occurred, the police went into the trailer. They did not have a right to go into that trailer. The warrant didn't come till the next day when they went back. The prosecution will say that the deputies were at the scene, were in pursuit of a dangerous suspect in a multiple murder and rape, and no warrant was necessary. Under the law, the police are allowed to do things like this in an exigent circumstances. This means that they can do things like search without a warrant if it's to prevent imminent danger of life or serious damage to property, or to forestall the escape of a suspect. The DA will say that this is exactly what they were doing when they were out there, and this whole situation was revolving around the fact that the dangerous suspect was not there, and they were trying to find him as fast as possible.
We talked about this on the Houston case, like the cops talking to him.
Right, on the side of the road.
Yeah, when they're like shooting back and forth. This I feel a little different about because I wasn't so sure about the other way. This one, there's kids missing. They don't know where the kids are. They need to, if they have to go into a trailer to look for kids, they need to.
Yeah, and I think the difference is that, they have a witness saying, Arturo did this to me. I don't know where my husband is. I don't know where my brother-in-law is. I certainly don't know where my children are. Find him. He did it over there. Like the cops have a direct line, and I'm with you. I don't see how there's a question, but playing that other side of the coin, though, that's the defense's job. Like they have to put that up there and say, yeah, but you're cops and you don't have a right to go into somebody's domicile without a warrant.
I am curious though, what makes this different? Because I agree with you, Sean, completely. The two kids missing, that they're looking for them, but this is also on Parnell's land, and I'm gonna assume that he lives in this domicile and doesn't pay rent because he works there.
Right.
So, I'm just kind of curious as to if they give permission to go in there. I appreciate that they, went ahead and got all the warrants and did everything the correct way. I don't know. Obviously, you have a right to live in a place and not have police just enter it willy-nilly. So, an interesting question I have.
And I kind of thought about this because I think it's different when rent is paid. If I'm paying rent on a house or an apartment, then it's my house. It's my place of residence. I have mail come there. It's mine. We know that Arturo Suarez gets mail there. He's got letters and stuff. He gets phone calls. Know whether the phone's in his name or somebody else's. I don't know that. So I don't know what the legal.
I guess squatters have rights too. So, but ultimately it's the kids that are missing.
But hang on a sec, though. On that respect, he's not a squatter.
No, I know, but I'm just saying.
So it would be interested to know. So if you're listening to this and know what the legal rule is for, I had my growing up, my father worked on a ranch for a while as a cattleman, and his house was owned by the guy who owned the ranch. But the phone was in my dad's name. The mail came to my dad. So we all thought of the High Lonesome as my dad's house, but it technically. So what is the legal if the cops came to that? Could they enter if the owner of the property gave them permission is what we're asking.
Also, think of wellness checks. Like people call in, hey, can you do a wellness check on someone? Thinking about the kids again. I think with missing people and the rape in the trailer, maybe not that part, but there's so many circumstances that would allow them in without them collecting evidence, but at least going in.
Well, and that's the DA's argument, that exigent circumstances mean that a police officer or peace officer of any kind can go into somebody's house if one of these things happen. A, we're preventing imminent danger to life or serious damage to property. B, forestall the escape of a suspect. And the DA says both of those things are happening. We're looking for missing children and missing men, and somebody that we have an eyewitness said that there was a violent rape and a beating occurred. It could be living. That gives us the right. However, because it's brought up, this is going to begin a 3-day trial where law enforcement from the different agencies are called to testify about the investigation and the initial couple of days spent at the ranch. So during this testimony, there were different versions of the same story offered. They would all have different details, and some of the differences appeared between the different witnesses. So the defense, and I think this is kind of smart too, because now the defense can get everybody kind of lined up before the actual trial and start seeing, hey, where can I poke more holes? And what they find is there are some discrepancies about time frames, about who goes in where and what they're doing and who's saying what. And part of this is because the responding officers aren't fluent in Spanish, and they're using a translator who's on the phone with them while Yolanda is with their one. So they're getting all, like we talked about earlier, they're getting all of this information from different sources. Plus, there is a violent felon that's running around, or a violent criminal that's running around that they're trying to capture. So I can only imagine the chaos of that scene, but between the phone and the victim distraught and trying to care for her, as well as make sure that there was not a dangerous person in the area, that would cause a ton of confusion. So some of the witnesses could not tell the judge directly where the information was coming from about Suarez's whereabouts and the state of the victim. So Judge Cousins will rule on this in late October. He would say that the search was valid as the defendant had fled the scene and that there were 4 missing people. But he would push the trial again. So again, and I think this is, I won't say that, and I don't know. So this is conjecture on my part. But we'll see that every time the trial date gets within a month or two, Talman throws up another one of these, as he puts it, it's not a roadblock. I'm trying to make sure it's done correctly, but it's enough so that they have to halt the proceeding, have a trial or a hearing, and then that actual trial gets moved back a little bit further. So this brings us to February of 2000. The defense is going to go to court and ask for a hearing about the DA reviewing the visitors' logs from Placer County Jail, where Suarez was being held. Now, I found this kind of odd. They show that the defense experts, so why would it matter that the DA is looking at visitor logs going in to visit Suarez? What the defense throws out there is that this shows defense experts coming in to interview Suarez about his health, his mental health, his state of being, all these kind of things. And they're going to argue that that gives the prosecutor an unfair view of their strategy before the trial ever starts. The DA will argue, oh, this is totally routine and not a problem. This time, however, the judge goes, no, that is a problem, and we're going to push the trial back even further. And this is one time where I think that seems wrong. Now, I don't know for a fact. It could be something regular, but it does seem like spying on your opponent. In March of 2000, the trial was moved to Napa, and Judge Wayne S. Snowden will hear the case. Defense wants the trial date of March 2001, but this would be rejected almost immediately because they're saying it's already been pushed back so much. Everything's ready. Let's get to going on this. The start date of the trial will be October 30th, 2000. Talman will ask for a later date, saying it's not enough time to mount a defense, which pulls us up to September of 2000. Now, I kind of glossed over, while we're talking about this, I glossed over the fact that the trial will be moved to Napa. I think they do make an argument, and it's a pretty good argument at the time. That's why we didn't spend a lot of time on it, is that the defense will say there's no way that this guy's going to get a fair trial in the area. And the judge almost immediately goes, yeah, there's issues about like cost and making sure that those kind of things are covered. But there's not much pushback. I think even the DA says, yeah, we understand. So it gets moved to Napa. In September of 2000, the defense tries to get the confession thrown out. And I should say the confessions, because remember, he's confessed multiple times to the police that it was obtained in violation of an international treaty. And this brings up what we talked about at the beginning of the episode of a 31-year-old treaty with the United States. The defense concedes that the confession was in violation of the Vienna Convention of Consular Relations. Now, this means that when he was arrested, that he should have been informed that he had the right to contact a representative from the Mexican consulate before he was questioned. Prosecutors will say that he was notified in a quote-unquote timely manner. At the arraignment, Suarez was informed of his rights to notify the Mexican consulate and was asked by DA Brad Finocchio, quote, "Do you want us to notify your country's consular officials?" unquote. His reply was simply, quote, "What for?" unquote. In an affidavit filed by Suarez, it states, quote, "I had thought I had to talk to police and was fearful that if I did not, I would be beaten. Had anyone told me I could have contacted a Mexican representative, I would have, because I did not understand my legal rights for the laws of the United States. I was upset, frightened, and confused by all of the officers and everything that was going on. I did not understand what a lawyer would or could do for me," unquote.
Do you know if Finocchio answered the question when he said what for?
No, that wasn't reported. I didn't see anywhere where it was stated like, we stopped and explained to him or not. They will mention a couple of times, and we'll talk about it, that he had been Mirandized a couple of times by this point. But again, and I understand if somebody doesn't have the facility with the English language, there might be an issue with that. I think the fact that this person murdered 4 people already, that kind of colors my opinion of it.
Well, the purpose of the treaty is to have someone familiar with the American justice system. Different countries obviously have different justice systems. And we've seen that in cases with Americans in other countries. So, you can be Mirandized, but if you haven't lived here, you haven't been, even people who live here, I would argue, don't totally understand what it means to not, how many times you have to choose not to speak out. And
how many times have we seen that where somebody's confessed to a crime not knowing what's going on, or having Miranda and not understanding, don't talk to the police,
or even having someone explain what the next steps are going to be in this judicial system. Judicial systems are not all the same on who has to prove innocence, or if you have to speak to police, which I don't happen to know in Mexico if you have to, but it very may well be that you do, and here you don't. So I understand in this case, we know this person did it, but at the same time, if it threatens them getting a guilty verdict or having that overturned.
Right. It's making sure. And I think we had talked about it before that they had been in, the DA's office had already been in touch with the Attorney General of California and said, this is what's going on. How do we proceed? And so I think on their end, but like you said, the devil's in the details, and it's these small things which turn out not to be very small, but that can hurt a conviction. Now, Luis Enrique Castriana Rubio, who was the consul from Mexico in the district that would include Placer County, files a statement that his office had not been notified when Suarez was arrested. He will go on to say that had he been, he would have advised that Suarez not talk at all until he was represented by counsel. So whether him or another representative of the Mexican government. Prosecutors argue that the notification at arraignment was, quote, timely given to the nature of the case and its investigative demands. Which, again, what does timely manner mean? Well, we did it when it came up while we were investigating. So that might be a little hard and fast with the rules, so to speak. This will incur a hearing about the legality of the confession. Most law enforcement agents may not know of this rule. In fact, those agents from the FBI and the Long Beach Police Department, LA, and Placer County Sheriff's Office will all testify that most of them were unaware that a rule even existed like that.
That I can understand the police departments, but I find it very strange that FBI agents aren't trained on something like that. You're dealing with cross-country things. You're getting involved as the U.S. government.
I would say yes for most of it, except for the fact that if we really look at the purview of the FBI in 1998, the purview of the FBI is crimes in the United States. they do not operate outside the United States. So while I would say that some of them may, with special permission, and that those individual offices may understand more and may have trainings as lawyers, I would argue that most of those FBI agents would not know what those international treaties are. And I'm with you 100% on the police. I don't think the average police officer probably know that at all.
Right. It kind of shocks me, actually. I just feel like I understand that they deal with in-state things, but at the same time, it just seems like you would think that you might be dealing with... You got FBI agents dealing with drug smuggling, correct? That's like an FBI... No? It's bank robbery only? Or things like that?
It's drug smuggling within the United States, but anything that deals with, like, that's the DEA or INS, or well, not INS, but like Homeland Security now and stuff. Like, I mean, originally, up until like the Patriot Act, you had silos, and the FBI really dealt with kidnapping, bank robbery, any crime in between state lines, but they didn't necessarily, unless there was unless there was an extra need and had special dispensation for it. You don't deal with international crimes.
There might be some crossover, though.
Yeah, but it's not enough to where, like, I as an FBI agent would understand all the treaties that require of arresting officials.
I don't know. This is 1998, and this is California. It surprises me. Long Beach, LA. How many people are being arrested then? And this right that they have is not being followed through on.
And there is an argument to be made with a state like California that has a massive amounts of immigration. Of, like, we have... we have a huge amount of immigration from Mexico. We have immigration from Asia. We have we're not only a tourist destination, but where people come here for all kinds of reasons. I will say that there's I would think that more law enforcement probably should know that.
Well, and this treaty goes both ways.
Yes.
So we would be livid as Americans.
Oh,
if,
100%. I'm not saying, and I understand, I'm not defending them not following procedure with this case. I think it's back to an instance of, I'm going to err on the side that most, if not all, of the officers did not understand that the treaty was required. They probably should. I will say that. I will think that if anybody, probably the DA, because they'd already mentioned it the day after when the DA was interviewed in the paper, before he had actually been arrested. They're saying we're taking precautions. We're calling the Attorney General, moving forward with this. They should have done it earlier. In fact, DA Finocchio said that it was not until 1 hour and 45 minutes before the arraignment that he received a directive from the state's Attorney General's office advising him of the rights that are guaranteed a foreign national under the Vienna Convention. So he's even kind of passing it back. He said, no, I called my boss, the Attorney General, and it wasn't until a little under 2 hours that we were going to our first assignment that he told me what we were supposed to do. So in that 3-week period, I didn't do it because I was unaware. The arresting FBI agent will testify that Suarez will talk freely about the murders, though he would deny the rape. She will also testify that he was read his Miranda rights in Spanish, but it was not advised of his right to contact the Mexican consulate, as she was not aware of the need or in fact that there was a treaty that was signed in 1968. The decision would be made in January after a lengthy hearing. Judge Cousins would say that the confession will stand. He would go on to say that the law enforcement not informing Suarez about notifying the Mexican consulate, while negligent, was not intentional and did not rise to the level of a constitutional issue. He will go on to say that the Miranda warnings issued to Suarez after his arrest were sufficient and that all the statements made by him would be admissible. He will point out that Suarez will talk freely to the authorities on 4 occasions, right after his arrest, on the ride to the station in Long Beach, to the FBI agents at the station, to Placer County detectives while he was returned, when he was returned to Auburn, and the last time when he walked through the crime scene. We didn't really talk about that, but there was a point when in the early investigation while he's in prison or in the county jail that they actually take him back out to the crime scene and have him walk around and point things out. So this guy's, not only is he retrod his footsteps in the crime, he's confessed 4 different times. The motion was denied, and again, the date for the trial will stand with jury selection to begin on February 20th of that year, with a start of testimony set for March 6th. The last thing that the defense will try is to attack the death penalty itself. The defense will postulate that the state seeking the death penalty is racially motivated. They're going to cite that in the past 10 years before this, there were only 2 prior death penalty trials and that they were both against minorities. Judge Cousins will respond, quote, "The court cannot conceive of a case that would be a death penalty case if this were not." So we're going to actually end this episode here. We have gotten to the point where the trial date is finally set. Jury selection is ready to go, and we'll continue this with our next episode that will be out next week that will deal specifically with the trial and the outcomes. So with our cold case this evening, Sean will take us through it.
Justin Vega, a 25-year-old Sacramento man, was hit while on his bike on his way home at 11 p.m. on Thursday, May 25th, 2017. He was riding to work at a brand new job at FedEx on Elder Creek Road in Sacramento when he was hit from behind. The driver did not stop, and his body was not found until 4 hours later. Antoinette Aguirre, his sister, will say, quote, "To hit somebody and not stop, to know that you hit them and didn't stop, that could have changed the whole situation," unquote. Her frustration stemmed from the idea that a phone call might have saved her brother's life. Quote, "If anybody called, even if you did it and you called and said, 'I saw a car accident,' anything, it could have saved his life." She became worried when her brother did not return from working the graveyard shift. She called in, but they said that Justin had never clocked in, but that they heard something about an accident down the road. That is when Antoinette drove to the accident site and saw authorities cleaning up the accident and removing her brother's bike. His family remembered him as someone who always had solid advice for his friends, who they jokingly called the Beast, for his willingness to always step up to a challenge. At this time, there are no suspects released, but police do have a piece of the car that was found at the scene. The family and community hope that this can lead to the arrest of the person or persons responsible. If you have any information, please contact Sacramento Valley Crime Stoppers at 1-800-AA-CRIME.
Thank you for listening to this episode of California True Crime. For a full list of our sources, as well as for more information on this episode or other episodes, head over to our webpage at californiatruecrime.com, where you can support the show by joining our Patreon, which has the option of ad-free episodes. Our web store is up and running with some new California True Crime merchandise. If you'd like to contact us, you can find us on Twitter, Instagram, and Facebook at Cali True Crime. Make sure that you're subscribed to our show to get our latest episodes. Leave us a 5-star review or tell a friend to get the word out about California True Crime. We'd like to thank our quality control engineer, Melanie Duncan. This was recorded at Snail Ranch Studios.